Everything here.
Mr. Smith, once you get to the podium, could you please state your name for the record?
Joshua Smith. Thank you.
Your Honor, today is the date and time set for a PCC in this matter. We would be asking for an adjournment of the PCC to complete discovery in this matter. I have gotten some initial discovery, but I believe there is more coming after speaking with Madam Prosecutor.
Is this the only thing holding it?
I'm sorry, Your Honor.
Is the only thing holding him?
Yes, it is.
Yes, it is, Your Honor. And we would like to address the matter of bond when the court is ready.
Cause conference July 11th.
July 11th.
2024, 9 a.m. Or as your invite indicates.
Thank you, Your Honor. May I address the matter of bond, Judge?
You may.
Your Honor, Mr. Smith has no prior convictions other than possibly a driving while license suspension case. I did run his iChat and it was completely clean. He's been incarcerated for 9 days since June 18th. He has retained counsel and is serious about facing the matters in front of him. He's a 30-year-old man that lives in Ypsilanti and has an apartment he's prepared to go home to. He's a lifelong resident of the Metro Detroit area, growing up in Canton and graduating from Plymouth High School in 2013. He has extremely strong family support in this matter. His mom, dad, and sister all live in Canton, and his extended family out of the state has been calling to check in on Mr. Smith and help in any way they can. His mom is a assistant deputy director of field operations for the Michigan Department of Correction, essentially in charge of supervising parole and probation, or parolees and probationers. His dad is a retired worker from DTE Energy. His parents have borrowed from their retirement in order to retain counsel on his behalf. Speaking to Mr. Smith's work background, he's obviously resigned from his job due to this case, but he has been consistently employed since his senior year of high school, working in various industries like food service, manufacturing, trucking, and hospitality. He is confident that he can become employed should he be released in this matter, and he does believe he has a lead on a case or on a job to become a janitor.
At first, this sounds like a familiar courtroom story. Clean record, strong family, job history. The defense is doing what defense attorneys do, building a picture of a man who looks stable on paper. And if you stop the video here, you might think this is just another bond hearing where someone deserves a second chance.
To review the police report in this matter, Judge, I would note that there's no mention of any injury to the complaining witness or no mention of any medical treatment. And based on that police report, I've done a preliminary run of his sentencing guidelines, and assuming for the sake of this bond argument only, that if he were convicted of assault with intent to do great bodily harm and he were given points under OV3 for bodily injury requiring medical treatment, maximum points for psychological injury to the victim, and maximum points for exploitation of a vulnerable victim, his sentencing range would still be 0 to 17 months, meaning it would be an intermediate sanction since it's an under 18-month sanction. And as this court is well aware, jail is not an intermediate sanction. So that presumptively this would be a probation sentence.
I understand how sentencing works. Go ahead, get to your end of your argument.
Okay, concluding, Your Honor, I would note that there was 14 days between the arrest and the incident in this matter where there were no allegations of wrongdoing. Mr. Smith was proactive in looking out and getting a booked therapy appointment, which he would like to get back to. We'd be asking for a cash bond that Mr. Smith can afford because we do not believe he is a danger to the community or a flight risk. We'd ask for a $2,500 10% cash bond in this matter, Judge.
But notice something important here. The argument quietly shifts away from behavior and toward math, sentencing guidelines, point calculations, probation ranges. When lawyers start arguing numbers instead of conduct, it's usually because the conduct itself is hard to defend.
Response.
Your Honor, we originally requested a $75,000 cash as surety in this case, and we were given $75,000 with 10% privilege. This is a case that was completely captured on video. The defendant is a teacher at Ypsilanti, was a teacher at Ypsilanti High School. The victim in this case is a 14-year-old student. Here, the victim and the defendant appear to have gotten into a verbal argument. At one point, the defendant instructed the victim to do push-ups. The victim told the defendant that he was unable to do so because he had a wrist injury. And then at that point, the defendant got in the 14-year-old's face and said, "That's some bitch ass shit." The defendant then followed the victim as he started to walk away. And at that point, he strangles him for several seconds with the sleeve of his sweatshirt. It was only when two teachers walked up and intervened that this concluded. The whole thing is on is on video. And aside from the physical acts of the defendant, what is extremely concerning is that in his own words, in his statement to law enforcement, when asked what happened, he said he had a headache and he snapped and he knew it wasn't right.
And then the truth drops. This isn't just an assault case. This is a teacher, a 14-year-old student, captured on video, a grown adult following a child and strangling him with a sweatshirt sleeve. That changes everything. Schools are supposed to be safe. Teachers are trusted with authority and restraint. When that trust breaks, the law treats it differently for a reason.
So I'm significantly concerned based off of the nature of the physical acts, which were all caught on video, but also the defendant's own admissions here about what exactly happened.
What really stands out to me is the defendant's own admission. I had a headache. I snapped. I knew it wasn't right. That's not confusion. That's awareness. And when someone knows their actions are wrong and does them anyway, especially to a child, judges listen very carefully.
They didn't request that I raise it. I actually should raise it, given what I've heard. I will not. However, your motion for bond reductions.
This is where the courtroom tone shifts. The judge isn't weighing sympathy anymore. She's weighing risk. Video evidence plus an admission plus a vulnerable victim equals concern. Real concern about control, judgment, and safety.
Your Honor, would you consider release if he was to live at his mother's house rather than by himself in Ypsilanti as a condition of bond?
Did I thought I ordered something.
I was just asking if it would sway your decision at all, Your Honor.
No, when I'm done, I'm done.
And when the defense tries one last angle, changing living arrangements, the judge shuts it down immediately. When I'm done, I'm done. That's not anger. That's certainty. Bond isn't about punishment. It's about trust. And in this moment, the court is saying that trust is gone, at least for now.